in the
Breakup
entire.
will not result in offense of rape.
My lord, the petitioner number one and the complainant met through Instagram. They both are doctors and they met through Instagram.
Oh, this is doctor versus doctor. All right. Yeah. What's for some promise of marriage?
Yes.
Promise.
ಎಷ್ಟು ವರ್ಷ?
From May 2021 up to 19/11/2023, my lord. For almost 3
ಡೇಟ್
years.
ಸಮೇತ ಹೇಳ್ತಾರೆ.
My lord, the petitioner number one, that is accused number one, and the complainant met through Instagram. They both are doctors and they met through Instagram.
Oh, this is doctor versus doctor. All right. Yes.
So, such being the case, their relationship blossomed into love and they entered into a romantic relationship with each other. And also, they have resided together in the same house from 10/8/2022 up to November 2023. They have resided in the same house, my lord. So, such being the case, there's some fights and disagreements started going on between both the petitioner number one and the complainant. So, this led to the complainant leaving the house.
No submission.
The settlement not
Settlement I want.
and
I'll pass orders on merits.
not says. She don't want.
Settlement ಅಲ್ಲಿ ಏನಾದ್ರು ಫಿನಾನ್ಷಿಯಲ್ ಕನ್ಸಿಡರೇಷನ್ ಇತ್ತಾ? ಏನಿಲ್ಲ.
She is not interested to not the prosecute the not the.
That I will pass orders on merits. The merits ಆದ್ರೆ ಸೆಟ್ಲ್ ಆದ್ರೆ.
Yes.
Well, Lord, recently there was a judgment on 20th November by the division bench of the Apex Court also regarding
ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಸಿಂಗಲ್ ಇಲ್ಲ. Yes. Lalu Yadav.
And not say.
it was published on 20th November 2024, my lord.
Oh, that is Justice,
Prashant versus State of NCT.
Justice B.V. Nagarata.
She has to go back to abroad for further prosecuting further studies.
Correct.
My lord, and
That I have
this
seen.
no ingredients is also present in the
Breakup
entire.
will not result in offense of rape. That's the judgment.
Yes.
The petitioner is before this court. Petitioners are in it.
Petitioners
Yes.
2 and 3 are parents of the
Parents
petitioner.
also. Yes. The petitioners are before this court calling in question proceedings in CC 18117 of 2024 registered for so and so. Heard so and so. Facts in brief, Germain, are as follows. The second respondent is the complainant who has had relationship with the first petitioner, accused number one. Both are, she's also a doctor, is it?
Yes.
Both are doctors by profession. The petitioners 2 and 3 are the mother and father of the accused number one. Well, it is the case of the prosecution that on 10/5/2021, the complainant gets introduced to the accused number one on the social media, i.e. Instagram, and began to message each other, began to exchange messages. The exchange of messages appears to have developed into friendship, and the friendship blossomed into relationship. Long thereafter, on the score that the petitioner has breached the promise of marriage, on which promise the petitioner had, accused number one had physical relationship with the complainant, the complaint comes to be registered by the second respondent on 12/2/2024. The police, after investigation, file a charge sheet. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would contend that the relationship between the accused number one and the relationship or any sequential acts on such relationship have all been on consensus and not on any promise of marriage. Even otherwise, the learned counsel would submit breach of promise of marriage cannot result in an offense of rape or offense of cheating, as the case would be, as is alleged against the petitioner. The learned counsel appearing for the respondent complainant would submit that the
Allegation do attract not of the offences and not charge sheet is filed. That much I can.
that is the learned counsel appearing for the respondent complainant would submit that the allegations are made. The police, after investigation, have filed a charge sheet and the matter must be permitted to be tried. He would, however, add that the complainant is wanting to pursue studies abroad and this pendency of this petition is coming in the way of her traveling abroad for pursuing higher studies. He would leave the decision to the court. The learned HCGP would submit that the complaint met the ingredients of the offences. Police, after investigation, have filed a charge sheet and therefore the matter requires to be tried. I have given my source. Therefore, narrated facts are not in dispute. The meeting of the petitioner for accused number 1 and the respondent on Instagram is a matter of record, as that is the narration in the complaint. The friendship happens on 10/5/2021, which, as observed here and above, blossoms into relationship and living together. The couple appear to have lived together for over 2.5 years, up to 2.5 years, and have had physical relationship, which the complainant contends that it was on the promise of marriage. On the breach of promise of marriage by the accused number 1, the petitioner, the complainant, seeks to register the impugned complaint. Since the issue has now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 34-35. It is the case of the complainant that they were in a relationship for close to 30 months, 2.5 years. The police, after investigation, file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 44. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is that the acts between the accused number 1 and the complainant were all consensual, and breach of promise and on promise of marriage or otherwise consent being taken as observed in plethora of judgments, it is an enigma. Therefore, the offense of rape cannot be met on the score that consensual acts between the accused number 1 and the complainant would not amount to a rape when the breach of promise of promise of marriage is breached. The interplay between the consensual acts and rape need not detain this court for long or delve deep into the matter. The apex court in the case of Lahingmadi. Subsequent to the passing of the aforesaid order, the apex court, in its latest judgment rendered on 20th November 2024, has held that mere breakup of a relationship between the prosecutrix and the accused therein cannot result in an offense of rape for all consensual acts that have happened in the during the course of the said relationship. The apex court in the case of Prashant versus State of NCT Delhi has held as follows. In the light of the issue standing answered by the apex court in the aforesaid judgments and the facts obtaining in the case at hand completely getting covered on all its force to the law as laid down by the apex court, the inevitable conclusion would be obliteration of the proceedings against the petitioners. For the aforesaid reasons, sounds allowed cost.
सिर्फ एक ब्रेकअप ने जब एक प्रेम कहानी को रेप केस में बदल दिया, तब कोर्ट की चारदीवारी में सच और कानून की असली परीक्षा हुई। यह मामला कर्नाटक हाई कोर्ट का है, जहां 2 डॉक्टर जो इंस्टाग्राम पर मिले थे, प्यार में पड़े और फिर 2 साल तक लिव इन रिलेशनशिप में रहे। पर रिश्ता टूटने के बाद महिला डॉक्टर ने पुरुष डॉक्टर पर झूठे विवाह के वादे के आधार पर रेप का आरोप लगा दिया। बचाव पक्ष के वकील ने सुप्रीम कोर्ट के हालिया फैसले प्रशांत बनाम स्टेट ऑफ NCT दिल्ली 2024 INSC 879 का हवाला दिया, जिसमें कहा गया है कि सहमति से बना रिश्ता अगर शादी में तब्दील नहीं होता तो उसे आपराधिक रूप नहीं दिया जा सकता और ऐसी स्थिति में मुकदमा चलाना कानून की प्रक्रिया का दुरुपयोग होगा। कोर्ट ने यह भी ध्यान में लिया कि अब दोनों अपने अपने जीवन में आगे बढ़ चुके हैं और किसी और से विवाह कर चुके हैं। इन सभी तथ्यों के आधार पर माननीय हाईकोर्ट ने आरोपी पुरुष डॉक्टर के पक्ष में फैसला सुनाया।